As you all know, Michael Chertoff was the second Secretary of Homeland Security. He was also one of the authors of the United States Patriot Act. What you might not know is that he is both the son of and grandson of rabbis, well-known, prominent rabbis, and known for their Talmudic scholarship. I've always admired Mike Chertoff because he has had the unbelievable ability to be both a man of thought and a man of action, and he's been a man of action in all three branches of the United States government. He's a graduate of Harvard College and Harvard Law School, Magna in both instances. He clerked for Justice William J. Brennan on the United States Supreme Court. He was an assistant United States attorney for the Southern District of New York, where he was a key player in the crackdown on organized crime and involved in the Mafia Commission trial. He later served as United States Attorney for the District of New Jersey and served in that capacity under both Presidents Bush and Clinton. Indeed, he was the only United States Attorney in the entire country who was asked by President Clinton to stay on. All of the other U.S. attorneys were replaced when the Clinton administration came in. He then repaid that by serving as special counsel for the Senate Whitewater Committee. And then with President Bush 43's election, he was appointed Assistant Attorney General for the Criminal Division in the United States Department of Justice, and he led the prosecution's case against Zacarias Moussaoui. In March of 2003, Secretary Chertoff was nominated by President Bush to the United States Court of Appeals for the Third Circuit. And just as he was getting ensconced in that position, a little less than 2 years, President Bush asked him to take on the role of Secretary of Homeland Security. And in that role, he was point man for comprehensive immigration reform. After leaving office, Secretary Chertoff created the Chertoff Group, which provides high-level strategic counsel to corporate and government leaders on a broad range of security issues, from risk identification and prevention to preparedness, response, and recovery. He is also senior counsel at the Washington, D.C. law firm of Covington and Burling. It is my great pleasure and honor to introduce Secretary Chertoff to you.
Yeah, Bill, thanks a lot for that very nice introduction. So I'm going to speak about the challenges that technology posed, legal challenges in the context of fighting terror. And the beauty of that topic is I can pretty much talk about anything, and it falls within the scope of the topic. But what I'm going to try to do is talk a little bit about the evolution of terrorist threat, the way in which technology has become a critical factor in fighting that, and then some of the legal issues that have arisen in the context of adapting the technology. And it's really my experience in my thesis that the law is often one or two beats behind what the technology is, and that it's that disconnect that sometimes creates a lot of stress between what the government wants to do in fight terror and what how the courts view that and how the public views it. And so part of what we need to do is to think through, maybe think ahead in terms of where technology is going. In fact, there's a certain category of technology that was really turbocharged by terrorism. On September 11, 2001, as Bill mentioned, I was the head of the criminal division at the Department of Justice. And in those days, there was no Homeland Security department, and so the responsibility for dealing with domestic terror was at the Department of Justice. It was a new administration, not that many confirmed positions, and I was on my way into the office that day, and I was on the phone, and my deputy said, there was a plane just hit the World Trade Center. And like probably many of you, I thought it was a private pilot who had gotten turned around. And as I continued into the office, he said to me on the phone, another plane hit. And of course, we knew that that was an attack. And so we immediately went over to the FBI Operations Center and spent the rest of the day and week up there trying to figure out who had done it, and most importantly, trying to prevent it from happening again. And what became rapidly clear was that the key to preventing it from happening again was gathering intelligence and information. In the 20th century, when we worried about the Soviets as the principal threat to US national security, and even going back to World War II, the way in which we detected a threat was radar, if you saw, or satellites. If you saw a missile being launched, or you saw an aircraft approaching, that was your warning, and then you reacted accordingly. Those are useless in a terrorist context where people get on planes like passengers and then make the plane into a weapon. And so that spurred the first revolution in technology, at least in the national security area, which was the dramatic rise of big data as a way of analyzing and determining where threats are. In fact, in the period of time right after 9/11, a number of private agencies that were in the business of analyzing data for purposes of credit scores and things like that, getting your mortgage, began to ask themselves, could you use similar techniques to determine who are terrorists? Out of this intellectual ferment, we developed an approach to dealing with transnational terrorism that involved the collection of data from three specific types of activities: the global movement of people, travel; the global movement of money, finance; and the global communication, the ability to intercept communications. And in a world in which the terrorists we were mainly concerned with were those operating internationally, if you looked at 9/11, you had training in South Asia and Middle East. You had some of the initial planning actually done in Europe. You had financing coming from the Middle East. And all of this had to cross boundaries, and then these people had to come into the US. And so by focusing on travel, communication, and finance, we knew that was where the data would lead us to be able to identify people that we needed to stop before they came in to carry out attacks. Now, this is a response to what I call terrorism 1.0, which was the original al-Qaeda model of terrorism. And that model involved bin Laden's really being a micromanager. He personally vetted a lot of the operatives to carry out attacks. He was very much involved in reviewing the detailed planning. His vision was very big, large-scale attacks. Now, obviously, when an attack like that is successful, it's devastating, as we saw on 9/11. And there were other attacks that were not successful that would have been devastating. For example, in August 2006, there was a plot to blow up a dozen airliners flying from Heathrow Airport to North America that, working with the British, we were able to shut down before that plot actually took off. But there was one element of that kind of big terrorism 1.0 planning that did give us a certain advantage, and that was the scale meant that there were many moving pieces, and therefore there was a lot of what they say in the trade, a lot of signal, a lot of information out there that if you could intercept a piece of it, you could follow the trails and you could actually stop something from happening. Now, out of this strategy of dealing with these vulnerable points, we started to look at collecting particular types of technological resources. First of all, we developed a program to develop passenger name record information that everybody gives their travel agent or their airline when they travel, including such things as point of contact, how you're paying, what your address is, what your destination is, where you traveled before, things like that. And we discovered as we developed a program to analyze this kind of data that had we had it back in 2001, we would have tracked 15 of the 19 hijackers through some form of connection to each other and to somebody that was a known terrorist some other part of the world. Maybe there was some out in East Asia or some in the Middle East. So that was a very compelling case. Likewise, we did this with respect to bank data, and through the use of legal instruments, we were able to require banks to give us information, again, that allowed us to see unusual money flows or money flows coming from people that we knew to be dangerous. And then finally, as many of you have read, because all this stuff got leaked out eventually, we ran a very energetic program of intercepting global communications. And the US technical skills that were very much honed in the Cold War were turned to finding terrorists. One byproduct of this, though, is that the model of what we were collecting intelligence on changed after 9/11. If you think back to the 1990s, we were interested in what foreign leaders were thinking and doing. So therefore, you're collecting against the Soviet leaders or the Chinese leaders. You're not really interested from an intelligence standpoint in collecting against so-called ordinary individuals. But the lesson of 9/11 is that's where the threat's going to come now. It's going to be ordinary civilians. This is not going to be driven necessarily by leaders, but it may be something that's detectable only in the conversations from the actual operatives. So from that, we retooled our program for collection against, in what's sometimes called the 702 program, against individuals in other parts of the world who might potentially be a threat against the United States. This, of course, after Snowden put his information out there, led to a lot of complaining from the Europeans about the use of surveillance technology against ordinary citizens, because that was a little different from the paradigm we had a decade before. So in this response to terrorism 1.0, we got into the first set of legal challenges, which had to do with privacy. And it wasn't really so much an issue in the United States as it was in Europe. The Europeans have a very different view, as many of you know, about the kind of data that ought to be collected and for what purposes. They tend to be very restrictive in the purposes and the predication for collection of data, and they tend to be very restrictive in the retention of data. From our standpoint, though, we had a completely different set of requirements. We had to be able to throw a very broad net over anybody who might potentially be a threat. And then we needed to be able to use data analytics to sift over that net and see, are there any connections that are suggestive of something that need a closer look? And then once you had that, you could then begin a more focused intelligence collection effort. One corollary of that, apart from the scope of what you have to collect, is the length of retention. Because the connection to somebody significant might not be evident for weeks or even months. So you need to keep the data for a considerable period of time to be able to run new information against existing databases. When we negotiated the passenger name record issue with the Europeans raised a lot of objections. Now, we had an absolute right under the Chicago Convention on Aviation to say to foreign air carriers, if you want to land in the US, you must give us your passenger name record data. So at the end of the day, we did have the trump card. But we still didn't want to shove this down the throat of the Europeans. So I had to go over to the Parliament in Brussels and lay out for them why collecting this information when you're dealing with terrorism 1.0, international terrorism, is critically important. And ultimately, the Europeans agreed, and we signed a PNR arrangement that they were willing to live with. And that's been re-upped over time. And I might add, maybe with a little bit of, I told you so, in the wake of what's gone on in the last year or two in Europe, the Europeans themselves now have adopted a similar program with respect to people coming into Europe. But we're now no longer only in the age of terrorism 1.0, although that still remains a concern. But we moved into what I call terrorism 2.0 sometime in the latter part of the last decade. And 2.0 still involves plots, but they're smaller scale, fewer people, less elaborate, and they tend to operate against soft targets. A classic example of 2.0 is the Mumbai attack in 2008. You'll remember that a number of terrorists came ashore in Mumbai, coming from Pakistan, and they operated for 60 hours, 60, in Mumbai, attacking hotels, attacking Jewish religious establishments, and killing people and with bombs and guns until finally, literally days afterwards, the Indians were able to get their quick response team, if I can use the phrase, in place to kill these terrorists. We didn't see a lot of that in the US, but of course 2.0 is what we're seeing much more now in Europe. You saw it in Paris, you saw it in Brussels. Now this is more challenging in some ways from an intelligence collection standpoint than 1.0. First of all, many of the people who carry out these attacks are citizens or residents of the country where the attack takes place. That's true in the US, where we had the Boston Marathon bomber or San Bernardino. So what that means is that the intensity and the level of communication and travel that we relied upon in detecting 1.0 will not necessarily be relevant in 2.0. Collecting in the Hindu Kush is not going to help you when the plotting is done in Boston. And you're not going to have PNR data when people are traveling on a subway as opposed to an airplane. So there are other kinds of technological tools and data analytic tools that have become much more significant in dealing with 2.0. And that has to do with the collection of metadata. So let me step back, and again, this is something that Snowden unfortunately felt a compulsion to release rather than dealing with his objections or his issues internally. A program called 215 was about the collection of metadata. Now, what is metadata? Metadata is the phone number or the IP address that is reaching out to communicate with another address or phone number, and it's the receiving phone number, and it's the duration of the call. It's basically the stuff that your telephone bill relies upon in order to determine what you ought to get billed. And it doesn't give any identifiable information unless you go deeper and you have a predicate to do that. It doesn't give you the content of what was said, but it does, again, establish connections. And as I said with 1.0, the key in terrorism 2.0 also, again, winds up being important in terms of who is connected to who, and if you can draw that connection to a known terrorist, that's something you want to take a closer look at. Now, after Snowden, the government declassified a number of opinions from our FISA court that deals with it, foreign intelligence surveillance, that actually dealt with the validity of this program. And not surprisingly, all but one upheld the program. There was one district judge here in Washington who had a somewhat different view. But there's no question that the overriding weight of judicial opinion was that this was perfectly appropriate to be collected under existing law. Existing law, as it's been for decades, has been that telephone billing records and similar data only require the barest legal showing in order to be collected. A subpoena basically will do, or an order on a very thin showing of relevance. But the fact that we were now collecting the scale of this data on an enormous amount made some people uncomfortable. And there was, of course, debate in Congress, and ultimately a decision was made by the White House to support a plan so that the data wouldn't be collected by the US government and held there, but it would be held by the phone companies and only checked when there was some predicate that suggested there might be some relevant information. Now, I want to be very clear about what the intelligence community did back in the days when they held the data. They did not willy-nilly rummage through the metadata. It was held, and it was only pulsed if, again, there was some predication, some reasonable basis to say, there's a number here that's questionable. Let's check to see who that number's been in contact with, and then let's just see what that second and third order of connection is. So, for example, if you found, that you had the Chertoff brothers in the Boston Marathon bombing had carried out a terrorist act, you want to see who did they speak to in the days and weeks before, because those might be people you want to follow up with. So it wasn't just a rummaging through all the data, but it really was about a targeted focus on inspecting. But again, as I said, with respect to 1.0, you needed to have the data collected so you could inspect it. I think as we move on, even in the post-Snowden era, one of the legal challenges is going to be, how do you reconcile the legitimate concern for privacy with the fact that if you don't hold the data and you're not able to search it when you have an appropriate legal basis to do so, then it's gone forever, and you've lost the ability to make those connections. And I think it's going to require us to think a little bit more carefully about treating collection as a little different than when you actually inspect or analyze data. And maybe instead of having it be an all or nothing proposition that you can only collect, once you've got some basis to know that you have something to collect, it might be more sensible to say, you can still collect and hold, but not look, but the looking comes when you have that predication. The third area, though, the third development in terrorism is what we're now living with now, although we still live with the other two, and that's what I call terrorism 3.0. That is the inspired or self-recruited terrorist. They haven't been trained overseas. They're acting probably alone. They may or may not even have been in direct contact with someone, let's say, from ISIS. They probably visited some websites, and they've probably done some things on social media that suggest an interest. Now, how do we use the technology to deal with this? Because here the technology becomes a two-edged sword. It actually becomes the basis in which people can be recruited and inspired to carry out attacks. So the ability to use social media to propagandize for ISIS, or the ability to use it to find people who are on certain websites and then reach out and cultivate and groom those people into potentially becoming inspired operatives. That's a situation in which the technology actually becomes the enabler of carrying out terrorist attacks. On the other hand, there are some things that technology gives to the people who are operating in the counterterror environment. It can give them visibility into who is trying to contact those websites or those particular individuals. It can give visibility into what is being said on social media. But there again, we run into a privacy issue. To what extent should the government be able to use its capabilities to scan what's out there in terms of social media and in terms of what people are doing, visiting websites, and to what extent is that beginning to infringe on First Amendment rights? To take it a step further, there's discussion now about the extent to which those who provide platforms for social media or Twitter or similar types of platforms ought to be monitoring and taking down sites or blocking things that appear to be recruiting and inciting. And again, that brings us into tension with what the line is. I think it's pretty easy to understand that when someone's directing somebody to carry out a plot, that's off limits and that ought to be stopped. But when someone's expressing unhappiness about policies, is that going far enough that you would block it or take it down? And I think this is a particularly big challenge with respect to the way we're looking at counterterrorism, not only in this country, but with our allies overseas. A third question is anonymity. Many of the people who are visiting sites that are recruiting sites or who are actually in touch with recruiters are doing so anonymously using, for example, services like the Onion router. The Onion router allows you to conceal your IP address because you can basically hop from multiple servers so that the IP address that's receiving the message only knows the proximate server that was the last hop in the journey, but you don't know what the first hop in the journey is. And these are commingled in a way that masks who actually made that initial communication. So you're saying to yourself, who created this Onion router, which is an enabler of terrorists? The answer is the Office of Naval Research of the United States Department of the Navy, which did it because originally the view was this would help American service people overseas who wanted to communicate on sensitive matters, masked where they were and who they were if people were listening or trying to intercept them. And then later this was viewed, and with some justification, as a positive tool for people who are dissidents, for example, like in Iran or in other parts of the world, who want to be able to communicate ideas without having the regime find them and punish them. So like many of these technologies, it's a two-edged sword. And one of the challenges now is how do we deal with anonymity when it becomes an enabler of terrorism? Two other technological legal challenges have arisen as we've worked from 1.0 to 2.0 to 3.0, and then I've left some time for questions. One is the issue of encryption, which has been pretty much in the news. You obviously all read about the FBI seeking to break the code on the phone of one of the San Bernardino shooters in the last year. And out of that, or in connection with that, there's been discussion about a legal requirement that would say to people who are either internet service providers or create devices that they either need to create a duplicate key to decrypt messages, or they need to create a backdoor that could be exploited, so if law enforcement comes with a valid search warrant, they can decrypt a message. The problem is this: as an engineering matter and a scientific and mathematical matter, if you weaken encryption by creating a backdoor or duplicate key, you've weakened it for everybody. So if the vast majority of innocent people who encrypt information that is sensitive or personal to them, if they find that their encryption is compromised, it's not only going to be the US government that takes advantage of that, it's going to be criminals who take advantage of it. So this is truly a case where the technological trade-off is between giving the government an ability to get by encryption when it needs to do so, at the cost of weakening the protection for everybody else. It's a little bit like saying, leave your door unlocked, because if we need to get into a house where a bad guy is quickly, we don't want to have to break down the door and get by the lock. The problem is, with the door unlocked, there are going to be a lot of bad guys in your house. And I think that's very much of a debate that we have to deal with now. The second challenge is we still deal with global terrorism. The ability to get access to important information is hampered by some of the legal rules that operate between countries. There are different standards, and there are different sovereigns. And sometimes when, for example, US law enforcement wants to get data that's held in a server in Ireland or in Europe or someplace else in the world, they go directly to the company, and they want the company to furnish that information that's held in the server in another part of the world. The company says, wait a second, our data is in a part of the world where they have their own courts. You got to go to those courts. That is very much an issue being litigated now, and actually the US Court of Appeals in the Second Circuit in New York has held for the time being that, in fact, you do have to go to the other country's courts, but that's clearly going to get litigated by the Supreme Court. And again, this is an area where technology has posed a challenge in counterterrorism, because in a world in which we now have the cloud, where data is not held on your PC or your device, it's not held in the cloud either. It's held somewhere physically, usually a place with good weather and good power and things of that sort. And that creates a problem when terrorists are carrying out an attack in one country and the relevant data is in another country. And we need to do a job of deconflicting the conflict in legal rules that occurs when the technology separates where the data is held from where the crime or the act of terror is taking place. So I haven't given you a lot of answers. I've raised a lot of questions. But I think the common thread, I would say, in everything I'm talking about is that the technology, as it moves very, very rapidly, has really deformed the existing legal structures. Rules, for example, about privacy and collection of data and the Fourth Amendment don't fit all that comfortably in a world in which, first of all, so much data is out in the open. It's technically public. But the volume of it and the ability to analyze it means the picture you can get of someone's life just from their public activity is dramatically greater than you could have gotten in the old days by wiretapping their telephone. Likewise, the disaggregation of data from where events happen has created issues about the way the international legal regime of exchanging evidence occurs. And finally, encryption demonstrates that tools will be provided by technology that will enable people to keep evidence secret or to keep their plans secret. And how we work around that without compromising the benefits of encryption is, I think, increasingly going to be a challenge for all of us. So I think there's plenty for the law to do in terms of examining some of the challenges that the new technologies pose, both to our safety and security, but also to our legal expectations about privacy and what our civil rights are. So with that, I'd be happy to take some questions. I think there's some folks with microphones.
First question.
And if you just tell us who you are. Yes, someone up here.
Could you comment on the amount of damage that Snowden has done?
Yes. I think he did quite a bit of damage. And I'd be careful what I say because I don't want to reveal things in the course of describing the damage that I shouldn't be revealing. But I think, first of all, what he put out was very much broader than what he would claim to be upset about. He claimed to be upset about the metadata program that I mentioned earlier, which involved collecting metadata on U.S. citizens to some extent. As it turns out, it wasn't that this was illegal. It was upheld by the courts. He just didn't agree with the courts. But even if you credit that as being based on a sincere, if misguided belief, why he revealed things about overseas or stole things about overseas collection against non-Americans or a whole host of other things, which he took with him in his computer, first to Hong Kong and then to Russia, I cannot be, in my mind, justified by his claims that he was offended by one particular program. He sounds to me at least a disgruntled employee who decided he was going to hurt his employer, or in this case, he was a contractor. And maybe there was something more nefarious at work there. In addition to revealing things which I think were of interest to our adversaries, including nation-state adversaries, he did a lot of damage, and maybe this was part of the intent, to the U.S. tech community, because the way he spun what he put out, with the help of journalists who had an axe to grind against the United States, the way he spun it was designed to create mistrust in U.S. tech providers and to promote overseas this sense of let's localize all of our data so the U.S. providers, the U.S. tech providers aren't involved anymore. And that's, of course, damaging to our economy. It's also damaging, by the way, to the internet as a whole. I also have to say some of the people who put this stuff out are clearly motivated by an animus. If you look at Julian Assange, in the most recent stuff he's put out based on the hack into the Democratic National Committee, he's all but said he doesn't really care what Russia does. He really thinks the U.S. is the bad guy. And, it's a little puzzling when you have a regime in Russia that when they don't agree with your journalism, they just kill you. That strikes me as less consistent with the First Amendment than any of the objections they have with us. So bottom line is he did a lot of damage, and I think it's slow to be repaired. But I will be honest and say that I think as Europe now experiences more terrorism, they may refocus a little bit more on keeping the security in mind as well as the privacy. Yes, somebody here.
This question is from someone who is totally unfamiliar with cyberspace. I'm the old generation. Why couldn't Apple simply take the San Bernardino cell phone and designate 2 people secretly to encrypt it? That would not jeopardize all the millions of people, and I could be wrong, I don't know the answer, who have the cell phone. They're not going to be encrypted, just this one. I couldn't understand how the Apple people came to the conclusion that if we encrypt this one or cell phone, it's going to impact all the millions of people.
So let me explain. So the particular thing that was at stake in Apple is a little different than the typical decryption issue. If you look at your phone, at least at that model, you had to punch in 4 numbers. Now, actually, decrypting 4 numbers is child's play. You probably can do it even without a computer. You just have to run every combination. The problem that the Bureau had was the operating system was configured in such a way so that if you try, I think it was 10 times, and you fail, it locks down totally. So the problem is not with the ability to decrypt, it's the problem with the feature is the operating system. You would have to write new code and create a new operating system that would allow you to remove that feature. Now, ultimately, by the way, someone was able to do that for the FBI without Apple, which is a whole other story. The concern I think they had was, once you've written that new operating system, first of all, you can't destroy it because there are backed up multiple other requests from courts to get similar functions with respect to the phone removed. And once you've written that code, it now exists, and now you've essentially created a back door to that particular feature in the operating system. And anybody who says, well, they can protect that against being hacked. I say the word Yahoo to you because you've all read that in 2014, Yahoo, a tech company, had something like, I don't know, millions and millions of accounts hacked. So I think that was the concern. What's interesting about it is that they were able to find a company, I think it was an Israeli company, that was able to break it anyway, which is why I think to some degree it was a little bit of a fictional fight that was designed to be a surrogate for what is the, I think, more complicated issue, which is the actual encryption itself.
Right here.
Yes.
So my understanding is that basically everything, whether it be in the government or in industry, is hackable and in fact being hacked by whether it's the Chinese or the Russians. I mean, is that basically the truth, that there really are no secrets out there? And again, how good are we? Are we as good or better than the Chinese and the Russians and our other adversaries in terms of hacking them and avoiding being hacked?
I'm confident we're as good or better than anybody, but I think what you say is true in a way and not in a way. And let me take a moment to talk a little bit about what your expectations ought to be in cyber. It really is not reasonable to expect that anybody who is connected at all with the internet or allows anybody outside access to their device with a thumb drive, it's not reasonable to suppose they will never get hacked, if by hacked you mean penetrated. What becomes important is reducing the risk of that, and even more significantly, reducing the amount of time someone is in your network. Because if someone gets in but you detect it within an hour, most of the time it's not going to cause any problem. It's when the adversary is dwelling in your network for weeks and months that you really start to have a serious problem. Now, why do I say that we shouldn't expect that anybody can be in a position where they won't ever get hacked? The analogy I use is the human body. If you look at your body is designed to keep viruses and bacteria out. But it's configured with the understanding that will not be 100% successful. That's why you have your immune system and your white blood cells. And frankly, when you get your flu shot, that's a form of information sharing. Essentially, we're taking the code from the flu virus and giving it to your white blood cells so they can anticipate it and then kill it when it comes in. If you went to your doctor and said, "Doctor, I never want to get sick," you'd be laughed out of the office. The key is reduce the amount of time you're sick and reduce the seriousness of the sickness. And I think that's the model I would suggest is appropriate when you're dealing with the issue of hacking. Last thing I will say is this, and it's always my opportunity to proselytize on this when I speak. There are some basic stuff you can do that removes 80% of the threat. I mean, it's not going to stop, a nation state, but it's going to stop a lot of less skilled adversaries. Things like having complicated passwords, not using the same password for multiple different kinds of functions. I personally do not use public Wi-Fi because I don't really feel like broadcasting what I'm sending potentially all over the place if it's not a password-protected Wi-Fi that I privately own. And my personal pet peeve is when you get a password-protected encrypted document that is sent to you by email, and then the next email has the password. Guys, So, I mean, there's stuff you can do to really reduce your attack surface area. Yes? A couple over there and some in the front row.
Oh, I'm so.
Barry Lang, GW Law School alum. My question, well, first of all, I agree with your statement that in and of itself, the collection of metadata is not a privacy issue. The privacy issue only comes about with the granting of the FISA court application to review the materials. However, there is a difference potentially in those applications and your normal criminal law magistrate application in that the scope of what may be reviewed is potentially much greater. Also, I note that the number of FISA court applications that have been rejected have historically been very few, at least the last records that I've seen. My question is this: there have been various proposals for the establishment of, for lack of a better word, a privacy advocate to review these applications and advise the FISA court as to both whether there's been a shading of the facts in the application or whether there may be a way of achieving the proposed objective in a more condensed, less extensive manner. What is your position on this idea or the many proposals for a privacy advocate?
So first, I mean, I know that there are stories out there that indicated that very few applications are rejected. I'll tell you why that is. It is because the Justice Department is generally highly risk averse in submitting something. Before it goes in, not only are they making sure they're inside the line, they're making sure they're well inside the lines. In fact, one of the criticisms of the Justice Department after 9/11 was that they actually did not use the full extent of their authority, even under the law that it was then, to allow information to be exchanged between the intelligence side and the criminal side. That was eventually remediated in the Patriot Act, but then shortly thereafter, basically the FISA Court of Review said, you know, guys, you could always have done this under the existing law. So I think that you get very few rejections because they're very careful not to get very close to the line. On the privacy advocate, I'd say this. To have somebody in there looking at the facts of every affidavit and reviewing it would, A, take too long, B, they're not in a position to do that, and C, it's really wholly unnecessary, and it's nothing that we do in the ordinary criminal law. I know there's a provision now to have a privacy advocate, and I could understand that if there was an unusual legal issue, the court might want to be able to have a cleared lawyer who could come in and argue the other side as a kind of an amicus. So, I mean, I think in that limited role, it's not a problem. I think there was originally a thought that, in a sense, it would almost be mandatory for the judge to listen to the privacy advocate. And I mean, Mike Mukasey was a judge much longer than I was, but I was a judge for a couple of years, as well as having been before judges a lot. And my recollection is if you try to make a judge listen to something that he or she doesn't want to hear, that is a colossal waste of time. So I think that where we're at now, where I believe the privacy advocate is available if the judge feels it would be useful, but not necessarily mandated, is probably the right balance.
Take one more.
Sure. One more, yes.
Susan Carmani and George Washington University Law School. Thank you so much for your remarks. In listening to them, I keep thinking about the old days of intelligence gathering, and particularly human intelligence. What is your sense of where we are on that in light of this great emphasis on data? Because in my mind, I think of mounds and mounds of endless data, and nobody's able to give any legal significance or any factual significance to it, and we're just overwhelmed.
Well, you know, I think you've put your finger on an issue that's discussed quite a bit. And as Bill said, I was at the Herzliya conference, counterterrorism conference, a couple of weeks ago, and then I was in Sweden on another one. And of course, with what I call 3.0, which is the inspired terrorist. And to be honest, some of these folks are barely inspired. I mean, they're essentially mentally disturbed individuals who at the last minute decide that they're going to pledge allegiance to ISIS, and they probably have no clue really much about what ISIS is, but they think it's glamorous, and then they go off and shoot a bunch of people. What we're seeing more and more is how do you collect human intelligence against them? And that's going to come from family members and local officials, teachers, workmates. You know, one of the things you find when you look at the guy who shot up a nightclub in Orlando or some of the other folks is that their workmates complained there was something funny about the guy. Or as in this fellow just very recently, who apparently there was a warning and the FBI looked at him and they didn't look hard, you know, they kind of gave him a pass. I think that's where we're going to have to start focusing our human intelligence for 3.0. It's going to have to be how do you get people in the community to feel comfortable speaking up, And what's our mechanism for dealing with that? And secondly, are we getting overly mechanistic or legalistic in the way, kind of check the box mentality when one of these things comes over? In fact, if you look back at the successful attacks or near successful attacks here, the Chernihievs, there was, I think, some notice from the Russians about this guy. The recent case is a case where, again, twice there was some kind of notification about this guy. The underwear bomber in 2009, his father in Nigeria went into the embassy and said, my son is a terrorist, he's going to do something bad. We've got to figure out how do you get, and this is where human behavior is important and human cognition. How do you get analysts to understand how you dig for that, rather than saying, okay, I'm going to check 9 databases, it's not there, and therefore we're done. So you're right to the extent you're saying to me, over-reliance on the data and what's easy to measure winds up atrophying what a really good investigator knows, which is how to go beneath the surface and do real interviewing and stuff. I understand there's a resource constraint, and I'm not critical because, you know, it's easy to miss something. But I will tell you, just from personal experience, you know, when I was Secretary of Homeland Security from 2005 to 2009, you know, President Bush, and I had been through the whole 9/11 stuff, so I knew emotionally what this was about, was hyper-focused on threats. And every week we met, and there was a discussion in the Oval Office with the FBI director and the CIA director and the National Security Advisor and a few other folks on the current threat stream and what's being done about it. And the one thing that regular meeting did is it focused everybody's minds in each of the agencies, and that trickled all the way down to the people at the front line, that this was really a priority, and you really had to kick the tires on this. And I know 15 years later, it's a little hard to keep that urgency up, but unfortunately, I think we're seeing an uptick in this new type of terrorism, and we're going to have to reinvigorate that process. So, thank you.